And we have been joined by the Honorable Madeline Archibong to my far right, and now we can finish. All right, so we'll just hold this for a minute and see if Mr. Frew comes in. The next item on the agenda is Section H, item number 13-0-1049, an ordinance by Councilmember Kwanza Hall to amend the Atlanta, Georgia Code of Ordinances, Part 2, Code of Ordinances, Chapter 2, to waive conflicting ordinances and code sections and for other purposes. And understand, Councilmember Hall, you have a substitute that you wanted to bring forward?
Yes, we can substitute and hold. There's still a little work in unreadiness, just to make sure that I'll pass this out to colleagues so you all have a copy.
Okay.
Shepherd, Mr. Copy.
Okay.
Well, the legal department is still working on a few tweaks, especially in Section F, Report of Actions, Open Meetings on the second page, on the backside. And there's some changes there, and maybe an additional whereas clause after the numerous Atlanta citizen statement. So we've got to give it just a little more time.
Okay, and I would just ask, in my first reading of it, if I would just ask that there be some definitions in the body of this that defines what a measure is, defines what a recommendation is, and defines what a meeting is.
Absolutely.
Okay, so we have a recommendation on the floor to substitute and hold. Before we vote, Mr. Cardinale has signed up to speak on this particular issue. Mr. Cardinale, you have the floor.
Good morning. I was just writing down what you said. You wanted a definition of what measure, recommend, and what else?
Meeting.
Meeting? Okay. Good morning.
Good morning.
Matthew Charles Cardinale, news editor of Atlanta Progressive News, and Vice Treasurer Fulton, Atlanta Community Action Authority. First of all, some of you know this already, but I wanted to share some exciting personal news, and that is that I have accepted a full tuition scholarship to go to law school. And I will be, thank you, and I will be, and that is to go to Gonzaga University, which is in Spokane, Washington. Gonzaga? Gonzaga. Yep. Yeah, it's in Spokane, Washington, private Jesuit university. They have a strong emphasis on holistic education and social justice. So it's a really exciting opportunity for me, and I'll be continuing Atlanta Progressive News, long distance, which is what I'll just have to do for the next 2 and 3/4 years. So anyway, so I'm just really excited about that, and so I have about 2 months left before I go. One of my top priorities is to kind of tie up some loose ends on this issue of the committee briefings that we've been dealing with for so long. And this legislation, basically what it does is it would amend the code, and it essentially sets forth that what we're doing now, what we've been doing since January, to have all 7 committee briefings be open to the public and treated just like any other open meeting in terms of pre-meeting advertising, etc., to set forth that we're going to do that in the future, and to actually put in the code a little bit about the briefings, which is actually, there's nothing in the code about what the briefings really are in the first place, and to set forth that they're going to be open going forward. This legislation actually came out of a conversation with Kwanza Hall, and thank you, Kwanza, for introducing this legislation. Actually, it was after the public comment debate, time limit debate, and Kwanza said, do you all just want to talk, or do you want to get some legislation going? And I said, okay, well, let's see if we can get some legislation going. So this, I thought, was kind of a no-brainer. I thought this was a really positive step for the city of Atlanta, and there are numerous people on this committee who should be recognized for taking the lead on committee briefing transparency. Felicia Moore, who opened up the finance briefings last year, Madeline Archibong, who opened up city utilities last year, and as well as Chairwoman Adrian for opening up the briefings of this committee, and Chairwoman Shepherd of Community Development for opening up that briefing. I think people forget that it kind of happened all at once, but it was really 7 decisions and 7 chairs who decided to do the right thing, so thank you for that. What this basically does is it amends a section of the code, 2-133, and the changes are in the second sentence of F. And what it would say is that all committee briefings, committee meetings, subcommittee meetings, hearings, and work sessions conducted by standing committees and select committees shall be conducted in accordance with all requirements set forth for meetings, as provided in the Georgia Open Meetings Act, OCGA 5014-1 et sequitur, and with the exception of executive sessions as defined in the Act, shall be conducted in open session with the public fully invited thereto. So literally how this works, and there was before it just said all hearings, and so in actually this was the language that was suggested by the policy staff, by Mr. Bernard Thomas, in terms of not just talking about briefings, but all the types of meetings that are open or should be open. So committee briefings, committee meetings, subcommittee meetings, hearings, and work sessions. The only one that we've really ever had a historical problem with not being open is the briefings. I mean, even when you have a work session and there's no quorum, it's open. When you have a hearing and there's no quorum, it's open. The only problem has been when there's been a briefing with no quorum. Sometimes those historically had not been open in the past. So, and I would point out also that these 5 types of meetings that are laid out here are the work of a committee, or the work of perhaps the full council, if the full council can have a work session or a hearing, I don't know. But it doesn't cover 2 council members getting together and having a conversation to address anything, or 3. It really only says a committee briefing. So it really only addresses when it is the briefing of the committee, or so forth. So I did want to address that concern. And what it does is there's been some dispute with the law department over whether briefings always have to be open to the public under the Open Meetings Act. That is an issue that we didn't settle in court. Our litigation is over, and in part because you guys opened up your briefings. So that was a great thing, and so we don't know what the Supreme Court might have said on that issue, and that's okay, because we have the opportunity to do the right thing and the best thing for the citizens of the city of Atlanta, because it's the right thing to do. And the Open Meetings Act, or what the law department says is required by the Open Meetings Act, is just the bare minimum of what we could or should do. There was a disagreement that, over whether, if there wasn't a quorum at the briefing, whether it had to be open. I believe legally it did, having to do with case law, Jersowitz v. Fortson. The law department maintains that they don't believe it has to be open if there's no quorum. Fortunately, we don't have to settle that legal question. And the great thing, if you actually look at the whereas clauses, the very first whereas clause, whereas the city of Atlanta seeks to provide its citizens with an excellent level of meaningful transparency, oversight, and public participation. Excellent, meaning to excel and to go above and beyond with regard to the operation of the committees of the Council of Atlanta. As I said, this would actually also in the whereas clauses you see, about that these have been held since at least 1998, and that the primary objective is to brief the chairperson regarding the procedural status of items on the agenda of the upcoming committee meeting in order to promote a more efficient committee meeting. So this actually, one of the things I found was that there was no legislative record or no rule, nothing in, in legislation historically that even established this practice that is so entrenched in what we've been doing for so long. So the rationale for this, obviously transparency, consistency, and simplicity for the public. The problem has been that everything keeps changing. Derek Bozeman actually called me and talked to me about his time on the council. Apparently this came up some 12 years ago, and he said that they were closed for a while, and then some reporter from the AJC asked a question, and then they were open again, and actually Dexter Chambers remembers some of this. And then it became, well, it's open if there's a quorum, but not, and then it became some of them are open, some are not. And now they're all open, but only because the 7 chairs have agreed for them to be open. And the chairs could change. We have an election coming up. The makeup of the council could change. We don't want to have to go through this again. And, I think they've been open for quite some time, all 7 of them. The sky hasn't fallen. It's been a great thing for the citizens. I think you even find that you're not bombarded with tons and tons of people. I know a couple citizens who go and who benefit, even today. I also would just say that I did speak with Kristen Denius and Amber Robinson about this legislation, an earlier version of this legislation, so they haven't seen this, and in part it's because Bernard made changes and then we worked together and made more changes, so they haven't seen this, but I would submit that the effect is the same and the goal is the same. Also, it doesn't require that briefings be held. So, I think Michael Bond said, well, what if I don't want to have a briefing? You don't have to have one, but if you have one, it has to be open. Also, just so you understand kind of the mechanics of it, as you can see, it says all, and then the list of types of meetings, shall be conducted in accordance with all requirements set forth for quote-unquote meetings, as provided in the Georgia Open Meetings Act. So the Georgia Open Meetings Act 5014-1 gives a definition for meetings. And then it says that anything that meets this definition of meeting has to be open, has to have advertising, has to have these things. And what we're trying to do here is to say that all these things, committee briefings, committee meetings, subcommittee meetings, hearings, and work sessions, shall be conducted in accordance with those requirements that are set forth for meetings. And what this does, I believe, is say that even if a committee briefing doesn't meet the definition of meeting under the Act, that we're going to still treat it as such. So, that's like, that would be like saying, doing an ordinance on watermelons and saying we're going to treat watermelons like we treat all special fruits. Well, is a watermelon a special fruit? We don't have to answer that question. We just know that we're going to treat watermelons as if they are a special fruit. So, again, I want to thank the people who have taken the lead on this, and I'm hopeful that I can work with the sponsor of this and answer any questions and address any concerns. I guess the only other thing that I would say is just a technical thing. I had originally drafted this to be a rule change, a change to the rules of council, and ensued a conversation with Rhonda Dauphin-Johnson about just the process of making a change like this. And so I guess there was actually something that came out of legislation in 1993 called the Rules of Council that attempted to bring together various rules that were in various places and to bring them into one document. Since then, changes to council procedures have sometimes been done by way of code and sometimes been done by way of rules of council. So I did find in my research some historical inconsistency, at least in the last few years, for how we've dealt with those changes. So this is presented now as an ordinance change, but the advice that I got from Ms. Johnson was that maybe the best thing would be to do both, to change the rule and change the code. So with that, I thank you very much.
Thank you. Ms. Moore?
Well, first of all, I just want to comment on a few things that were said, and to clarify. One, I don't think there's a dispute anymore. If there was one, I know in years past, back when you were talking about Bozeman, I was here. I don't know that there is any dispute as to what a meeting is or what the open records law says, and I'm sure you're aware of that through the changes that the General Assembly made, and it's very clear what a meeting is or is not. And you know, our law department has been very vigilant in making sure that we follow the letter of the law as it is now. And so when you said that has been a legal dispute of that, that's not necessarily true. There is no legal dispute within. Ms. Denius is very adamant about, and she babysits us at every meeting to make sure that we don't run afoul of the law, so we don't have to run into any problems. And you made the comment that the only reason we have briefings open now are because the committee chairs have chosen to do it. We don't have a choice if it is a meeting. And I know the president had asked for us to make a decision one way or the other based on, again, our law department saying to us that they suggested that if we're going to have those meetings, so that there won't be any opportunity for the law to be violated, that we open them to the public as well. So we're consistent with that. The only problem I have with this is I'm not quite sure it's necessary, particularly the language where it specifically states that our meetings should follow Georgia law, because we have no choice but to follow Georgia law. Okay, she wants to speak. Let me finish my comment and you can clear me up. I don't think we have any choice but to follow Georgia law. Now, one thing that we don't have or didn't have in our code, which the rules have been put in our code, specifically that, you know, we might hold committee briefings or subcommittee meetings or work sessions. So if anything, that's the question, whether or not we want to specifically lay those out in the code or not. But if they are a meeting, we don't have any other choice but to follow the law. But Ms. Denius wanted to say something. If you don't mind, Ms. Chair.
Okay. Yes, Ms. Denius.
Good morning. My name is Kristen Denius. I'm a senior assistant city attorney.
Yeah, if you can take, good.
Sure.
Good.
Thank you. I actually have had an opportunity to see kind of how this has been progressing. I spoke with Saul this morning and we looked at some of the new language. And the one thing I do want to clarify is that the law department does believe that this paper is necessary if, in fact, you want to require briefings to be open. Our legal interpretation of the current state law is that you do not have a meeting, you have a gathering, but not a meeting subject to the Open Meetings Act if you are short of a quorum. So what this paper would do would be to require briefings short of a quorum to be held in an open fashion, which is, I think, what Mr. Cardinale was trying to get to. As a law department, we don't have a problem with that if that is your decision.
But let me ask this then, and I hear what you're saying, but why is that any different from any other meeting that we hold? For instance, if we hold a work session, there's plenty of times, sometimes it's only the chair, maybe another person that comes to a work session, but we just call them a meeting and we open it and we send out legal notification, et cetera. So why would a briefing be different? Other than I do know that we don't have any specific language in the code related to a briefing.
Right. Ms. Moore, I think what you're describing is historically you have been voluntarily conducting those other types of gatherings in accordance with the Open Meetings Act without being required to.
Okay.
So you've just been choosing to do that in the past, and this paper doesn't mean that you would be choosing to do anything differently with those in the future. It's just sort of making it more uniform and giving everybody guidance. So, like I said, we don't have a problem with that. It does sort of codify what you've already been doing with these other short of quorum type gatherings. So it would be relatively consistent with your practice in other areas. But our legal opinion is that it's not a requirement of state law to do that for either any gathering that you have short of a quorum. So
Yeah, I understand that, but I guess it's just overkill. It doesn't hurt to do it, but I see that the other ones are mentioned, even though, like I said, I know all those other meetings and the committee briefings now are all done that way. So-
Right. And the only other suggestion or recommendation that I would have with the language in the paper as it stands is to avoid referring to committee briefings as meetings, or referring to anything in the law other than just a general citation to 50-14-1 at SEC. I'm uncomfortable with the pulling out the specific mention of the executive session. If we just refer to the law itself, that
And then
should be
let the law-
sufficient. And that way, if the legislature tweaks it or anything like that, we don't have to worry about coming back and making sure that our code is consistent with what they do.
And so Ms. Adrian, I know, was asking for definitions, and so we won't need to define what a meeting is if we just go based on
I wouldn't
what-
recommend it, because
Okay.
if our definition is slightly different from theirs or appears to be slightly different from theirs, then it can cause us problems and confusion later on down the line.
Thank you, that helps. I just didn't understand. It just seemed like overkill, but I guess overkill doesn't hurt.
All right, we have a motion.
Is your mic on?
I'm sorry, we have a motion on the floor to substitute and hold Mr. Hall.
Well, so are you still unready with this, or?
Well, I think her explanation helped me get to it. Like I said, it doesn't,
Yeah.
I don't have a problem with that. I know that I was going to say, should we just narrowly talk about committee briefings because we didn't have them in the code, but I'm fine with what she said. I'm ready, okay, with the changing it just to, as she said, just cite the code section and leave all that other stuff out.
Yes, and how do you feel, Ms. Adrian?
Sure.
I just don't know what no measure or recommendation means, because I understand what no voting means, but I don't know what no measure or no recommendation means. I mean, we recommend to rearrange our agenda, we recommend to change times, we recommend to break for dinner. I mean, so my unreadiness is,
Well, do we even need that section is the question.
Ms.
Yeah,
Dennis,
so-
do you hear this?
Kristen, the section 2-133, do we even need that section?
I have to be honest, I'm not familiar with where that sits in the code, so I would hate for you guys to remove something. Just, I haven't looked at it.
This is to amend that.
Okay, yeah, this is to replace it. So can I just read what my recommendation is for
Sure.
what I would like it to say? And this is just
okay,
my...
and while someone is addressing us, I'd appreciate if the people who are not addressing us to step back, please. No helicopters. Okay, take a seat somewhere, please. Thank you. It's just not polite.
Okay, so I would have it say, Section 2-133, Operations Procedures, subsection F, Report of Actions, Open Meetings. No measure or recommendation shall be reported out of any committee unless a majority of the committee members are present at the time such action was taken. All committee briefings, committee meetings, subcommittee meetings, hearings, and work sessions conducted by standing committees and select committees shall be conducted in accordance with the Georgia Open Meetings Act, OCGA, Section 50-14-1 et sec. Period.
Well, yes, but she still didn't answer my question, but go ahead.
I think this will answer your question. I think that there needs to be a new section, because this section talks about that no measure or recommendation shall be reported out of any committee unless a majority of committee members are present is one thing. What
Which
they're
is actually a
asking for
quorum.
is something
Right,
different.
that's a quorum.
And I think that they need to be separated, because putting them together means that if you had a briefing or anything, nobody could talk about what happened in that. I just think they need to be they're two separate issues.
I think I see what you're saying. I'd have to look at the whole section, honestly. I haven't looked at it as an entire.
Yeah, and this is the whole section, you might want that, he said quorum is covered under C. I think we need to, it just needs to be a new section.
Right, because
Yeah.
my difficulty is that I'll use the example of our budget hearings. Our budget hearings are open to the public, but it is rare that we have a quorum. Work sessions, rare to have a quorum. There are just countless meetings where you might have just one or two or three council members, and that council member might decide to, I don't know what they're allowed to decide, because I don't know what no measure or recommendation means.
Well, just taking a quick glance at it, I think that F originally was intended to require a quorum in order to take action. So I think that I agree, it may be confusing to put this particular amendment with, when we're talking about meetings specifically that don't have a quorum, in here together with that. I agree with you, I think that's confusing. My recommendation would actually be to amend the whole section and add a new paragraph H and kind of
And so,
Renumber the
since you're the writer,
well, this is operations and procedures of meetings, and so I think it's the right section, but I think we need a separate paragraph.
okay, so, Mr. Hall, do you mind if she takes the time to do that and we
Sure.
address it next go-around?
No problem.
Do you mind?
I'm happy to.
Thank you.
Okay. Thank you. And did you have a comment? Did any other council member? Okay.
The striking of, can I say something to
Yes,
respond
sir.
to this? Okay. Okay, well, that, I think that was a very productive and helpful discussion. And, you know, I will definitely be available to work with Kwanza over the next 2 weeks on this. As far as the concern about the work sessions, and you said like the budget hearing, that would be an example of a meeting that, or gathering, that doesn't have a quorum, that historically has been open, right? But doesn't have to be. So I wouldn't describe it as overkill to put in here that we should do it going forward, because y'all could change your mind at any time, as with the briefings. And so we're trying to not worry about people changing their minds. The other language change that I don't know, she read it to you and there wasn't much discussion, so I don't know if you caught this, was to change it to shall be conducted in accordance with the Open Meetings Act. And to me, that doesn't do enough, because we already have to conduct ourselves in terms of meetings and gatherings with, we have to comply with the Open Meetings Act anyway. So that already is the case, and if there wasn't a disagreement over what was required for non-quorum briefings, then we wouldn't have had a dispute for 2-3 years over that. So instead, by saying, shall be conducted in accordance with all requirements set forth for meetings as provided in the Georgia Open Meetings Act, once something comes under that meetings definition, then it has to be open, then it has to have certain things. And this isn't saying that a watermelon is a special fruit. It's just saying that we're going to treat watermelons with all the requirements that come with special fruits. And so we're not admitting that a briefing is a meeting, but we're saying that we're going to treat it as such. And I'm happy to work with whoever to craft something that's a compromise on that. One other thing I wanted to say, and I kind of wanted to say before I moved to Spokane, is that we have some very hardworking people who work for the City of Atlanta who I wanted to recognize. And, Kristen Denius is one of those people. I have seen Kristen, you all debating something, and Kristen needing a document and literally running to the law department to get it. I've seen Kristen respond to me on a Sunday. And same thing with Rhonda, who I don't know if she's still here. Rhonda works sometimes 9 p.m. at night. And so I did just want to say that, because there are people who go above and beyond for the City of Atlanta, And we should be proud that we have city employees and not privatized employees like some of our sister cities in our metro area. Thank you.
Thank you. All right.